was 5/12/2022, my lord. Thereafter, no matter was listed. Therefore, this mention is made.
What is the urgency?
Urgency, my lord, selection of vice president, my lord, of Gaon Panchayat, my lord.
Give a date. Huh? Let's give him, he'll fix the date.
May I please? May I please,
Yes.
Lordship, with the consent of the other side, Lordship, I would make to mention item number 11 and 12, Your Honor. Kindly it may be adjourned for the date today.
Who, on whose prayer? Your prayer.
Yeah, on my.
What is your name?
SS Gupta, Your Honor.
Mr.
SS Gupta.
S.S. Gupta, Learned Counsel for the petitioner. Prays that the matter may be adjourned and submits that he has taken the consent of the other side. Praise the Lord. This is the matter after
Few vacations, Your Honor, the senior.
after the Bihu vacation. 11 and 12.
May I please, your lordship, I pray for listing of the matters for orders
Give a day. He'll give a date.
on Friday.
No. Why? What is the urgency?
My lord, I am the shareholder of the cooperative society. I am the private respondent and the matter is not listed after a long time. I am deprived for the post of the selection process of the post of the chairman, my lord.
Okay. When was it last listed?
Last 25/1/2023.
Give a date.
Bless my lord. Lordship, I would like to mention for item number 8, 9, and 10.
Yes.
With the consent of the other party, let the matter be adjourned for a week.
Where is your adjournment slip?
No,
No adjournment slip.
no, lordship.
You come out of the blue
Lordship, I will
and you
display.
give a surprise to everyone. What happened to your senior?
Actually, he is having some personal difficulty, lordship.
Like what? He's in court number 1.
No, lordship. Some personal difficulty, lordship.
Where is he?
He is in home, and lordship is not well. So,
He's not well.
8, 9.
Okay, right. Adjournment prayer has been made on behalf of Mr.
Dr. A. Todi.
Dr. B.P. Todi. A. Todi.
A. Todi.
Mr. A. Todi. Adjournment prayer has been made on behalf of Mr. A. Todi, Learned Counsel for the petitioner, who is apparently unwell. This is accordingly list this matter after
1 couch.
2 weeks.
And your
May I please, your lordship? Lordship, with the consent of other side, I like to mention item 14 of today's daily lordship.
Yes.
Lordship, I like to seek for an adjournment, lordship.
Why?
Senior counsel is not available today. Dr. A. Saraf.
Right. Adjournment prayer has been made on behalf of Dr. A. Saraf, Learned Counsel for the petitioners. So it is also noticed that adjournment request had been made, which had not been objected. Accordingly, the matter is adjourned for 2 weeks.
Lordship, there is the interim, your lordship.
What interim?
On the last occasion, there is interim.
No. Why should we allow the interim? You argue the case.
Yeah, senior counsel is not available.
You tell me why I should continue the interim. Why should I continue the interim? Huh?
I understand. Your lordship.
Huh?
I understand, your lordship.
You understand? Understand what?
What you have said, your lordship, I have understood.
Okay, interim order to continue till the next day.
Much obliged.
May I please, lordship, I beg to mention item number 2. We need some time for filing an affidavit in reply by the respondents, and my senior is out of station. Kindly adjourn the matter after 3 weeks.
Right. Adjournment, right. Miss, what is your name?
P. Singh.
B. Singh.
P. Singh.
P. Singh. Singha.
Singh.
P. Singh. Appearing on behalf of
D. Das.
Mr. D. Das, Learned Counsel for the petitioner. Is granted 2 weeks time to file affidavit in reply.
3 weeks, my lord.
3 weeks time to file affidavit. Yes.
I can.
2. Any objection?
Lordship, my lord, that item number 2, my lord, is becoming instructor already been.
Just show me-
Lordship,
just show me
I
item
will see the- I have filed my affidavit long back, lordship. It was filed on my lord, 31/5/2022, lordship. Contextual work, it has been already been completed. Only
Just
because
a-
of
just a
tendency
minute.
of this rule, my lord, the payment could not be made, lordship, to the, my lord, that contractor.
Okay, so the contract work was given.
Lordship. It has been completed, lordship, already,
To respondents number 10 to 15,
lordship.
and
And
it
the
has
sum
been
of-
completed.
Lordship, one of the malad respondent, he have the received the malad that contextual amount, lordship. And others as malad, due to malad subject of this malad that matter malad could not be paid. Malad in March ending malad, we have to pay the amount, that amount, otherwise malad it will be. Yet some problem, lord.
Where is your senior?
My senior is out of station also.
Where is he gone? You don't know where he's gone. What kind of a junior are you? You don't know where your senior is gone. What, how do you communicate? By email? You don't go to his office.
Lordship, malad, that can it be fixed on malad Friday, lordship?
Get fixed day after tomorrow.
Lordship.
So contractual work, all those contract works have been
All been
completed.
completed, lordship.
All
My lord, there is
completed.
no stay order, my lord, that, my lord, only my lord, my problem is that, my lord, some of the contractor, my lord, they did not receive the contractual amount, lordship.
So if there is no stay order, what is the
Only because
problem?
of, my lord, that the matter was sub judice, that's why, my lord, it was not been paid.
So what is your problem with that?
My
You are
lord,
the
that's-
government advocate.
lordship.
Then what is your grievance?
My
You don't have
grievance,
any
my lord, if,
problem.
we are not paid the amount, my lord, it would be, my lord, again, my
Lapse.
lord, lapse. That is the problem.
Right. No, adjournment prayer has been made on behalf of Mr. D. Das. Full stop. On the other hand, Mr. J. Handing, appearing for the state respondent, submits that the contract works which have been put to challenge have already been completed by the concerned private respondents. And as such, nothing remains in this writ petition. Full stop. On considering the above facts, list this matter day after tomorrow.
Obliged, lord.
Day after tomorrow. Now, the prayer for just a minute. This is the matter day after tomorrow.
Lordship, I beg to mention an item for listing of tomorrow, Lordship. The urgency is that we have received a letter that there is a recovery proceeding initiated against us against for the forest royalty. Now arbitration proceeding is already pending, Lordship. During this pendency, they have issued that letter. Now the time is 31st. This is the last date, Lordship. Tomorrow, Lordship.
Day after tomorrow.
Day after tomorrow. I'm deeply obliged. Lord.
Wait, please, your lordship. I've actually mentioned for listing on contempt matter, lordship. This court was passed order, lordship, but the responding authority FCI were not complied the order. So
What order?
lordship actually at the risk and cost of the contract, lordship, in between the private contractor and the FCI, lordship. But they did not allotted the work, lordship, till date. So
When was the order passed?
already order passed in WPC number sensor, but the
Already passed, we know, madam. When? I said when.
lordship, tomorrow, lordship,
When was it
Oh,
passed in the WPC?
lordship, 1st of March
March of
of 2023, lordship. We have
23, and what did the order say? What does the order say?
order say that I am the contractor and continue to give me a.
Show me
continue
the
to
order,
work.
let us see. I don't know. It'll come in their own time. What is the hurry?
Lordship, actually, my contract was expired on the next month, lordship.
I don't know. We do not know.
Oh.
It'll come. Give it.
I seek my lord's indulgence to mention for listing of a motion matter tomorrow.
Why
It's
tomorrow? What is the matter about?
the petitioner who is before your lordship, he has been directed to vacate the tea stall. He's running a catering stall at Guwahati and Kamakhya railway stations. And that tea stalls has been, they have ordered to vacate the tea stall. Yesterday, I had moved another matter. Similarly situated co-petitioner had got interim status quo order from this honorable court, lordship. May I pray for listing tomorrow? Motion.
No notice was issued to you.
No, my lord.
Notice must have been issued to you.
No, my lord, these are all, they are running their tea stalls since 2005, 2010.
Maybe.
And they are, these catering contractors are guided by a catering policy of 2010. The respondents railway have interpreted that the.
Tomorrow we are fixed, madam. Oh,
So my
huh?
lord, a similarly situated co-petitioner has already got this status quo order from yesterday, my lord. That order covers my case. And also there are Delhi High Court and Supreme Court order in this regard.
When are you asked to leave?
31 lordship,
Day after tomorrow.
day after tomorrow.
My lord, I'm paying for listing of a matter tomorrow, your lordship. The urgency is that we had been allotted some land in the year 1998, your lordship. Government has thereafter sanctioned funds for development of the land. Now suddenly they have come for threatening eviction, your lordship. Though it is a set allotted land to us, your lordship. And surrounding areas have already been evicted without notice, your lordship. Police is visiting our premises now, your lordship. So we are.
Day after tomorrow, day after tomorrow.
Tomorrow, your lordship.
Day after tomorrow. There's no time. How does it matter one day? Nothing will happen. They will not kick you out in one day.
The surrounding areas have already been evicted, your lordship. In Guwahati, Silsako area, your lordship.
Day after tomorrow. How does it matter?
Tomorrow if they come.
Huh?
Because already surrounding areas have been evicted.
What have you constructed there? Have you constructed anything in that
Yes,
land?
yes,
What have you
yes.
constructed?
There are multiple buildings, your
Is
lordship.
it a concrete building?
Yes, yes. your
If it's a concrete building, then that they cannot throw away the concrete building. That the concrete building will remain.
Because in surrounding areas also concrete buildings were there, those were evicted, your lordship.
The
without
persons
notice.
were evicted.
Yes, your lordship. Entire houses were demolished, your lordship.
Have you, okay, tomorrow, let's see.
Much obliged, your lordship.
Houses were demolished. Are you sure?
Yes, your lordship. Silsako area in Guwahati. Your lordship.
May I please, your lordship. Lordship, I would like to mention for listing of a matter for withdrawal matter.
May it please your lordship. Lordship, I pray for listing of a matter next week. It is a pending matter, my lord. It pertains to a settlement of a fishery, my lord.
Huh?
It pertains to a settlement of a fishery, my lord. Any day
Next week.
my lord. Obliged.
We have asked for removing the glass already, the others come out.
May I please, your lordship. My lord, second bail application, lordship. My lord, as on today, I am 130 days in custody. 130 days in custody,
Only?
lordship. Allegation is also serious, lordship, section 4 of the POCSO Act.
Then, why should you, your case was rejected earlier. Why should it be allowed now?
Lordship, now, my case was rejected when, at the time when I was 87 days in custody. It is
Ah.
now 130 days, lordship. My lord,
That,
yes, record may be called for lordship in this case.
so you are married,
Married, lordship.
married to the victim?
Yes, lordship, married. I have.
Is it?
stated-
But no, my lord, in the last order also, it was reflected that no documents they have submitted regarding
Oh,
this, my lord.
correct.
But
How
I
do
have-
we know that you are married to that?
My lord,
Statement is there, lordship. I have stated so, lordship, in my.
You just, that live streaming has to be stopped. In this POCSO matter.
charge is already framed, my lord. Victim is yet to be examined, my lord.
Victim is yet to be.
My lord.
That is the same problem
lord,
that
my-
had occurred earlier
Same
also.
status at present, my lord.
Lordship. Since there's a-
Why, if you see, why can't the victim come here straight away and say,
Lordship, earlier due to boycott of the court, the statement of the victim could not be recorded, Lordship. Bilasipara Special Court, Lordship, that was boycotted by the Learned Council's Lordship.
Huh?
Special Court Bilasipara, that was under boycott by the Learned Council for about 3 months, Lordship. For that
Look,
reason.
Mr. Council, if you all are married, where is the document? Some document.
Lordship, I have stated, Lordship.
You have stated earlier also.
Yes, the children also born out of their woodland.
We do not know, we do not.
Lordship, page 8, paragraph 12, may kindly be seen, Lordship, I have stated.
I do not know, Mr. Council, they are coming to this. They are coming in the same plea without any additional
No
fact.
new grounds,
nothing.
no
Huh?
new grounds, no new grounds.
No new grounds.
Lordship, I have order, the latest order I have annexed, Lordship, annexer 8, page 62 onwards, Lordship. My lord, the court has resumed, but the witnesses could not be examined, Lordship.
Maybe, but then if you are married to her, I do not know. How difficult would it be for that lady to come here?
Yes, Lordship, record may be called for on.
No,
next
no,
date I
no,
will
no.
produce-
I do not, you produce her, you.
Yes,
produce-
Lordship,
no,
I will
no.
produce that document,
No,
Lordship, on next
it's
date.
not the- not
That
the-
may be
not-
recorded, Lordship.
Heard, Mr. I'm dismissing this thing.
Lordship, my statement, my submission may kindly be recorded. I will produce a record regarding marriage and the record may be called for. My submission may kindly be recorded.
Why? You had all the time in the world to do it. On the first, why should we, it's the same thing. You withdraw this file of fresh bill application.
Fairly submitted, Lordship. Problem is that their relation is not now that of my lord, though married, their relation is under some problem, Lordship. My lord,
We do not
That is
know,
the
you
problem.
said you have children with her, where is the children? No proof, nothing.
yes, Lordship, I will produce my submission. may be
You're
recorded.
supposed to produce here. Not in your submissions.
Due to that problem, Lordship, due to that problem, I could not proceed. I will try like on the
No.
record call, Lordship.
You withdraw, I'm dismissing. Heard, Mr. M.I. Hussain, appearing for the petitioner.
Withdraw, Lordship. Withdraw, Lordship.
Who prays that he may be allowed to withdraw the bail application, as he wants to file a more comprehensive bail application. Mr.
B Sharma, my lord.
B. Sharma,
Additional PP.
additional PP appears for the state. The prayer of the petitions council is allowed. The bail application is closed and withdrawn with liberty, with liberty of state law.
Obliged.
In this matter, Lordship, Mr. M.K. Sorori, senior counsel, he is appearing for, he is in court number 1, just for timing, Lordship. I have informed the other side.
Let him come, Mr. Chaudhary. He says that Mr.
This is
Chaudhary has
court
been
number
engaged.
1, just for
Let
timing.
him
Once
come.
he is here, Lordship will take out the
We
matter.
are here, Malad, the moment he comes.
Obliged.
Yes, you can start the live streaming again. Live streaming, you can start. Okay. No one appears for the petition again, huh? As usual,
Continuously,
continuous.
they don't seem to be pursuing.
Right, none appears for the petition on call. Mr.
As
S. Barwa appears for
I appear for the pollution control board, respond number 2.
correspondent number 2.
I put 3, 4,
While
and 5.
Mr. M. Goswami appears for respondents number.
3, 4 and 5.
What about 1? M. Goswami appears for
Forest,
3, 4 and 5, huh?
Forest.
One is forest law, we are not referring for.
3, 4 and 5. No one appears for 1.
Close.
Full stop. No one appears for respondent number 1. Full stop. In this case, a brick field was set up at village Naujan Bill Pothar within Saru Pathar PS of Golaghat district by the respondent number 8. And the petitioner who is a neighbor has filed the present petition stating that the brick field is operating without clearance from the Pollution Control Board and the administration. Okay. Hey, order dated 16/6/2014. according to law. What is the stand of the Pollution Control Board?
In fact, we have filed a very brief affidavit. So from this affidavit, I could make out that in fact, this land is, yes, is a non-agricultural land. So that land has been, and the distance maintained by the brick industry is perfectly as per the norms set by the Pollution Control Board.
Okay, so the brick kiln
Yeah.
is set up with the permission of the Pollution Control
Yes,
Board.
yes.
The affidavit in opposition, Ms. Para, the affidavit in opposition filed by the respondent number 2. Bracket Pollution Control Board. Is to the effect that permission had been given for setting up the brick kiln. Full stop. Next paragraph. On a perusal of the earlier orders passed by this court, it is seen that the petitioner has not been represented on the last 3 occasions. Full stop. The above facts gives rise to an inference that the petitioner is not interested in pursuing this matter. The writ petition is accordingly dismissed for non-prosecution. No one appears for the petitioner on call. Yes, Mister.
Lordship may record my name, is A. Chandia for the tax department. Lordship.
Mr. A. Chaliha appears for the
Finance and Taxation Department.
Financiation and Taxation Department. 2014 matter, what is this?
Lordship, here.
Till now, till it. The next para, the order dated 15/2/2016 passed by this court is as follows. Huh. However, even though more than 6 years, 7 years have elapsed, the matter is still pending in this court. Due to various adjournments made by the parties and non-appearance of the petitioner at times. What to do?
The Lordship may post the matter, giving the petitioner one last opportunity after we whom.
Stop. In the interest of justice, come on, this matter is adjourned for the last time. List the matter on. Twenty. 2004. 2023. Come on, which date an attempt shall be made to dispose of the case. What to do?
So in fact, a detailed affidavit has been filed by the government. So the stand of the government is very clear. In fact, they have been trying to confuse the court with regard to two different darks. So one dark, there is encroachment free, there is free from any kind of occupation. And another dark government has already settled with some cultivators. And here the petitioner says that they have been settled with those lands in way back into 1944, whereas they have failed to produce any such documents or dark number whereby the settlement has been given to them. So in this respect, even though the petitioner is not there, I would not press for a disposal, but the fact remains that they don't have a case here. And in fact, the trace map submitted by the Kanun Go.
So there was
It is not similar with
a
what-
eviction notice issued to them.
Yes, yes.
Eviction notice was issued to them.
No, in fact, they were not occupation of that particular land. It was free from any occupation. That has been the stand of the government.
No, but their case is that they have been in occupation of the land.
No, that is not a fact. That has
It
been,
may not be a fact, but that is their claim.
that is their claim, but that
That's right.
claim has been denied by the government.
I know, but
Yes.
I'm asking what is their claim? I'm not asking your.
Their claim is that they have been in occupation for so long. It has been settled way back in 1944.
But they have not given
but
any
that-
dark number,
That has
nothing.
been controverted here.
Okay, right. No one appears for the petitioner. Mr. B. Sharma appears for Vishnu.
As Buru.
S. Barwa, sir, S. Barwa. Appears for respondent number.
One she's appearing. I appear for 2, 3.
Two.
I am 1 and 4.
Miss
G Hazarika.
G. Hazarika appears for respondents number 1 and 4. While Mr. S. Barwa appears for respondents number
2 and 3.
2 and 3. Pushkar. The case of the petitioner is that they have been settled with the land since several decades. Now that they have settled on the land since several decades. And accordingly, the eviction notice should be set aside. But on the other hand, the case of the state respondents is that the petitioners are illegally encroaching upon illegal encroachers. And they have not been able to produce any land documents. In the interest of justice, list the matter on when? After 2 weeks.
As your lord.
List the matter after 2 weeks. why aren't they here otherwise?
That's what I am also amazed.
May I please?
Yes, Mr. Jairaj. Yes.
My lord, this matter pertains to my lord, refund of tax, my lord.
Just a minute.
The petitioner, my lord,
Refund of tax.
tax, my lord. Now, the petitioner has paid tax on turnover. As well as, my lord, the TDS was deducted by GMDA. That was deposited after 2 years, so that amount was the excess paid amount. Because tax authority has deducted that on the turnover.
Just tell me the case. I do not know. There's no, yes, what? For which year? Tax for which year? What?
2009, 2010, my lord.
2009, 2000. Yes,
Lordship, Mr. B Chaudhary is in Lakes at court number 10, your lordship, he pays for this matter.
and he prays for this matter for what? He prays for this matter to be heard today or after 2 years or 2 months or what?
Learned, senior friend submit, make a submission, you may be allowed to
They
submit.
have not filed any response to my writ, my lord. Neither GMDA, neither the tax authority.
Then? Do you know the consequences of not filing an affidavit? What? What are the consequences?
Lordship may take it at 2 o'clock, my lord. Let them.
I don't know if we will last till 2 o'clock at the rate that we are going. There's no lawyers.
Otherwise, my lord, I place documents which clearly says even the Supreme Court judgment is there, my lord. They have verbally said that my claim is time barred. But my lord, from the record, it appears it's not time barred, my lord, but they have not issued any letter or neither any response to the representations made by the petitioner, my lord.
Okay,
And
you
that-
tell me your case. Tell me your case.
My lord. If you-
Otherwise, there's nothing much to be. There's only one item 15 left, I think, after this. Item 15, who is the counsel? Mr. Anyone for item 15? Oh, you're there. You're ready. But I do not know if the other side is ready. You're both ready. We can think of them
That, and lordship will take it 2 o'clock, my lord, then, or maybe after this,
after this.
let it,
Yes. Yes,
may it please your lordship. I'd like to briefly. And
just a minute.
Page 79 is the interim order, lordship.
Just a minute.
79, lordship. Annex 11. So order of the Deputy Commissioner Hailakandi, lordship, regarding
You on page 79.
page 79, lordship, Annex 11.
Yes.
So may I read, lordship, the entire order?
Yes.
In the order dated 1/7/2017, passed by the Commissioner of Barak Valley Division, Assam, and arbitrator appointed by the central government, white so and so, dated so and so in arbitration case number so and so, bypasses including widening streets of Hailakandi district in connection with acquisition of land for construction of NH 154, double laning NH road, also seen and perused the order dated 28/8/2018, passed by the Honorable Guwahati High Court in WPC number 915/2015, Serimul Haq Sodial and others versus the Union of India and others, received by the office on 5/1/2019. In the aforesaid order, it is in that the affected persons have already received the Jirat, trees, plants, etc. as per schedule rate of the year 1990, which is to be updated as per schedule rate of the year 2009-12 in respect of certain stretches of NH 154 and revised assessment of land value and assessment of building, etc. in Hailakandi bypass should be updated considering the base year 2011. In compliance of the aforesaid order and for updating the Zirat value, trees, plants, etc., the revised assessment of trees, plants, etc. for the year 2010 to 2012 has been obtained from the District Agricultural Officer Hailakandi by letter so and so. In respect of agricultural products and revised assessment of forest products as per government approved rates obtained from the Divisional Forest Officer Hailakandi by letter so and so, which is to be put against the name of the affected persons without changing the name of trees, etc., size and quality of the plants. As regards for a reassessment of land value of villages, Rangpur Part 8 and Rangpur Part 3 under Katlisara bypass, the land value of the said villages be updated considering the rates of land value of its neighboring villages like Rangabad Part 3, Part 2 and Rangabad Part 1 under the said bypass as assessed in the original LA by the then DC CA Hailakandi by order dated 9/1/2009. As per records, it is seen that at the rate of rupees 3 lakhs per bigha was assessed for village Rangabad Part 2 without classification of the land. It is also seen that at the rate of so and so per bigha as homestead land and at the rate of rupees 2 lakhs per bigha as arable land of village Rangabad Part 1 was fixed by the order dated so and so. Hailakandi and payment of compensation has already been made to the affected persons. It is also seen from the record that in respect of village Rangpur Part 3, the bigha rate of homestead land had been fixed at the rate of rupees 1,75,000 and rupees 1,50,000 per bigha as arable land of village Rangpur Part 3 and 8. Considering the bigha rate of the said neighboring villages and as per arbitration order dated 1/7/2017, the bigha rate of the affected villages, that is village so and so, be updated rupees 3 lakhs per bigha as homestead land of village Rangpur Part 3 at the rate of rupees 2,50,000 per bigha as arable land of village so and so. Considering the same distance of the villages from our semi-urban area of Katlisara headquarters. As regards revised assessment of building, etc. of Hailakandi bypass, considering the base year 2011, the revised assessment of building, etc. as per SOR 2011 obtained from the Executive Engineer PWD Building Division, Silsor, height so and so. Land value of Hailakandi bypass considering the base year 2011. The land valuation report from the Assistant Settlement Officer Hailakandi and Lala circles have been obtained. It is seen from the reports.
Yeah, where has been obtained? Where are you reading have been obtained?
80 Lordship.
No. You see, there is it joint? Or
Continuing.
it says at page 79, wide letter number so and so dated 15/6/2019. Then you have got this
This is continued to
continuation. Is it a continuation?
continuation, Lordship. The page 2, above page 2.
There, I don't, there.
It is seen from the reports of the ASOs concerned that the average bigha rate of the 10 number of revenue villages of Hailakandi bypass arises as follows.
Where are you reading?
Page 80, Lordship.
Which part? Okay, as follows.
Lordship.
So you've got 10 villages. Now, look, let us be very clear. Which village are you from?
Lordship, regarding Lordship, this is Hailakandi bypass and 10 villages, Lordship.
How many petitioners are here?
113.
113.
Lordship.
So you are all from the same village or different villages?
Different villages, Lordship.
Different villages. Okay. Now, what is your case?
Lordship, my case is that, Lordship, in earlier assessment, Lordship, some amount was fixed for land valuation, Lordship, as per their classification of land, homestead land, arable land, etc. And thereafter, an arbitration case was instituted. And this order is also here, Lordship.
Huh?
And These order is also in record, Lordship. Order of the arbitrator is also in this record, Lordship. And not in the arbitration order, Lordship, it was followed that in certain area, the
So
classification
that has been raised, the amount of compensation has been raised.
raised, Lordship, but Lordship,
You have not been given the amount.
no, that is not the case, Lordship. In that case, my lord,
What is your case in a nutshell? Just tell me, what is in a nutshell?
Lordship,
What is it? You want your compensation has not been paid, partly paid? What? You're not been paid interest? What is your case? You're only reading, you're just not telling me your
we are,
case.
Against this order, Lordship, in this order, what happened, Lordship? We have challenged the earlier assessment order that we have not given the proper land valuation.
Ah.
There
So arbitrator has given the valuation, so this order will stand.
Lordship, arbitrator has given certain, Lordship, direction to the assessment authority, Lordship. That you have, you should follow this type of procedure while assessing the land valuation, Lordship.
So that has not been done.
By this order, Lordship, they have completed the process. This order, DC order, Lordship, and in this order.
Which order? Page
this order-
80?
Yes, Lordship, page 79 to 81, Lordship. And here, Lordship, in this order, Lordship, we have challenged on the ground that, Lordship, they have not followed the procedure which the arbitrator has given to be directed to follow, Lordship.
Oh, okay, you're challenging the arbitrate, you're saying that this order,
This
page
order.
79 to 81,
Lordship. Here,
Have-
Lordship, we have-
has not been made in terms of the order given by the arbitrator.
Lordship,
Just give me, this is under the National Highways Act.
Lordship.
Now, this is a writ petition. Can an arbitrator's award be challenged in a writ petition? Let us see the National Highways Act. I think it's 35G. What is it?
Only thing is that we are not challenging the arbitrator order, Lordship. That implies-
Okay, you're not challenging the
No,
arbitrating
we are
order.
not challenging.
You're challenging the
Order of the.
order of the deputy commissioner, which has been made in consequence to that.
We have a very simple prayer, Lordship.
Okay.
Kindly have a look at this, Lordship, page 80, Lordship.
Page 80.
Page 80, Lordship, second part, Lordship, kindly see, Lordship.
Yes,
May I read, Lordship?
yes.
It is also seen from the earlier assessment of the Bigha rate in respect of the aforesaid villages as per order of the DCCL, which are as follows. Here, Lordship, kindly have a look at first village, Lordship. Loxibon part 2, class of land, homestead land, roadside land, arable land. Different lots for different land, different assessment. But in the present Lordship assessment, they have taken it as a whole. This is our Lordship grievance. Lordship. We wanted, my lord, in this assessment also, as per classification of land, the land should be valued, Lordship.
Huh? No, you see. Now, for Lakshir bond, they are giving big up rate
Bigha rate at the
at
rate of
1,23,744.
Lordship, this was a current assessment. The previous assessment, I like to draw Lordship kind attention in the second part, Lordship.
Huh.
It is also seen that in the earlier assessment. From that table, the first
So
line,
the earlier assessment was higher.
higher Lordship, it was done as per the Lordship classification of land, Lordship. Third column, Lordship,
Whatever it may be,
Lordship.
please answer the question.
Lordship.
Don't go into your back into your own, your own comfort zone.
Lordship.
The question is, the earlier assessment was higher or not?
Earlier assessment, in some villages it was lower, and some villages it was.
I'm talking about, let us go one by one.
Lordship.
Let us go to Lakshir bond.
Yes,
Was the earlier assessment higher or lower?
higher.
But Narayanpur is much higher
Yes.
now.
Yes.
In the earlier, it was lower.
It was, in three villages, it was lower, lordship, and now higher.
So you want that Narayanpur, these should continue. The latest assessment should be accepted for the ones which are higher.
No, we are not on that. Lordship.
Not on that.
We have a very simple and lordship,
Let
limited.
us see your prayer. I'm not understanding it. I'm not trying to. If it was so simple, I don't know why I'm taking so much time.
I have a limited period.
Just a minute.
Lordship.
There is something, it is not. Your documents, they are not connected. There is something missing all the time. Page 79, 80, 81, they are not connected. Come to 81. It starts from land compensation. From where does it start? Come to 81.
Lordship.
Where are the words prior to land compensation?
Lordship, is the document of the government itself, also they have also perhaps annexed this order, lordship.
The link is missing.
Yes. So they are documents.
Yes, Mr. Goswami, what is the prayer of the petitioner? I do not know. What does he want?
We have assessed the land value on the basis of the three sale deeds, lordship.
Three? Sale
Three sale
deeds.
deeds of
Ah.
3 years, continuous years, lordship.
Uh-huh.
And according to them, lordship, according to arbitral order, lordship, they fix more value of the land. lord.
Huh? Where is the arbitral award? Let us see the arbitral award. You
Page, lordship.
are going into some
62,
different tangent altogether.
Page 60, lordship.
Page 60.
Annexure C, lordship, in the description.
I'm not understanding at all what your case is. What do you want?
I may be allowed to, lordship, kindly have a look at the second table in the page 80, lordship. Page 80. Other restriction, lordship.
Yes.
Lordship, this is a table, lordship, regarding earlier assessment, lordship.
Ah,
Lordship, first column is name of the village, lordship.
yes,
Second is the bigha rate,
yes,
and next is the class of land, lordship.
yes,
First, lordship, in the bigha rate at the rate of 5,50,000 for a classification of land, homestead and roadside land.
yes.
Now, lordship, the problem is that, my lord, you kindly have a look at the above table, lordship.
Yes,
Here, lordship, they have not assess the land as per this class of land. And we will look at this. This is the simple reverse.
No, there should be a classification of homestead and roadside land.
Lordship.
And on one side and arable land on one side.
Lordship. And in the affidavit of their government also, they have not given this lordship. Kindly will look at.
But then
the-
it'll be, it could be lesser, the amount could be lesser, then
Then also we will accept lordship, but it should be done according to earlier assessment. They have adopted this procedure lordship. This is the limited prayer lordship.
We have reassessed the land according to the price sale date, Lordship.
no, but then how can you sell it? Can the, you see, homestead and roadside land and cultivation land,
Lordship.
that will be different rate. When there is a house standing and there is some your kheti somewhere, can it nearby or behind the house, will it have the same value?
No. In page annexure H, Lordship, page 115 of our affidavit, Lordship, we have made the average of the land, Lordship.
How can you make average of the land?
Page 115, Lordship,
115?
of the affidavit, Lordship. Serial number.
Yes.
So the sell this Lordship and land value is there big, ultimate, that the average land is
What is the average?
down below, Lordship. 3,72,900, Lordship.
How can it be? These are all, you see, Mr. Council,
Lordship.
1, 2, 3, they are all different persons.
Yes,
How can you make it 372? They are different persons,
the difference sell date, Lordship. Yes.
huh?
Difference sell date.
Then you added them up and they said that this is the sale, this is the price.
Look.
372 for this Narayanpur, let us see. Narayanpur, where does it say 372? Come to page 80.
Lordship.
Where is this 372? Come to page 80.
Serial number 694 for part 3. There is different one.
So, where is the argument? What are you saying? Yeah, huh? You're totally lost, it appears. I was lost, you're even more lost than me. His case is that cultivable land,
Yes, Lord. For my-
land on which houses are built, they should be given different classification, different
Right.
compensation amount. You cannot compare kheti with your residence.
Lordship.
That is his case, correct?
Lordship.
And where does the arbitrator say so?
It's, lordship.
In that,
Page 62, lordship. And it's got award,
Huh?
page 62 in award part, lordship.
what part two?
Lordship.
Yes, okay, this two.
No.
Yes, come to page 62.
Lordship.
Come to awards
Lordship.
and number 2, please read number 2.
In case of Nala bypass, the year of land valuation seems to be fine. However, it should be valued as per type class, such as homestead, cultivations, etc., and has been done in case of other bypass.
That is what he's saying. He's saying accordingly, this thing should go.
Right.
And the thing should be made as per the arbitrator's award.
Right.
Which has not been challenged and actually has been acted upon, but not in the manner it should have been. Yes, are you there, Mr. Barwa?
It's for national highway.
I am on national highway. but
Yes, what,
my
what,
address only follows this particular road is not constructed by NSAI. That is a, I have, in this fact, I have filed a video also. This particular road in question and land in question we are dating not constructing agency.
You are not the constructing agency. So are you a party here?
Yes, party, I have filed.
Who is the constructing agency?
Here, my lord, this if I go ahead, change.
Whoever may be the constructing
This
agency.
is act, I think NS 56 is follows. We have to act accordingly, because NS 56 of says because though I am not party, I have seen this arbitrary award to be followed.
Okay, right. Mr.
R. Fukan.
R. Fukan, learned counsel for the petitioners. Also heard Mr. N. Goswami for
6 and 7 Lord.
6 and 7, and Mr. C. Barwa for
T.
this point number 3. Anything else, Mr. Goswami? Right. The petitioners grievance is with the order dated, no date. Order dated 1/7/2019. Passed by the Deputy Commissioner and competent authority, comma. Ministry of Road Transport and Highways, comma, Hailakandi. Huh? Hailakandi? Ministry of Road Highways, Hailakandi. Is it? Deputy Commissioner is Hailakandi, comma, which was made in pursuant to the award dated
1/7/2017.
1/7/2017 issued by the arbitrator in terms of the in terms of section 3G of the National Highways Act 1956. And the order dated 28/8/2018 passed by this court in WPC number 915/2015. Page 65. Next paragraph. The petitioners counsel submits that in terms of the award dated 1/7/2017 passed by the arbitrator, comma. Compensation on land value has to be done as per the type/class of the land, comma, such as homestead, comma, cultivation, bracket, arable, bracket close, etc. Full stop. The petitioner's counsel submits that the land of the petitioners had been acquired for widening of the national highway number
Hailakandi bypass road.
for widening of the Hailakandi bypass. What is this? Lala bypass? It's called Lala bypass or what?
Hailakandi.
Hailakandi bypass. Hailakandi bypass. Full stop. He submits that instead of following the directions passed by the arbitrator in his award dated 1/7/2017, comma, land valuation has been done without making any classification of the lands between homestead and roadside land. Homestead land and arable land, comma, as had been done earlier in other compensation cases, in other land acquisition cases, in other land acquisition cases. He accordingly submits that the impugned order dated 1/7/2019 passed by the Deputy Commissioner and passed by the respondent number 6 should be set aside and a direction should be issued will make reassessment of the land valuation in respect of the lands affected by the Hailakandi bypass by making assessment, different assessment rates for acquisition of homestead and roadside land on one side and arable land on the other. Full stop. Next para. Mr. N. Goswami, learned counsel for the respondent number 6 and Mr. C. Barwa for respondent number 3. Submit. No, just say Mr. N. Goswami, learned counsel for the respondent number 6 submits that he has got no objection.
No.
Huh?
My submission will be recorded that was reassessed as per the pre-sale discount.
Submits that the impugned order dated 1/7/2019 has been issued by the respondent number 6 in terms of the directions passed by the arbitrator in his award. Correct, that's all.
And reassess the land as per the sale deed of 3 consecutive years.
Further, the land has been reassessed on the basis of
Sale deeds.
huh?
Sale deeds.
On the basis of 3 sale deeds pertaining to the said area. Next para. Mr. C. Barwa, the learned counsel for the respondent number
3.
3 submits that the road widening
Reading question is not constructed by NHAI.
submits that the the road in question has not been constructed by the NHIDCL
NHAI.
by the respondent number
3.
3
3.
and as such
I don't.
and the respondent number 3 has got no role to play in the present case.
Yes.
I have heard the learned counsel for the parties. Full stop. The arbitrator. No, full stop. Next, right. The facts of the case is that the lands of the petitioners were acquired for widening or construction, for widening the Hailakandi bypass. Under the National Highways Act 1956. Who was the implementing authority? Which company? Which respondent? You do not know, huh?
Most probably, my lord, I also, NS, it will be state.
Now, who is the authority?
Other than my lord, NSA, DCL and state PW, NS division constructs. And I think.
Who has constructed this road?
Respondent number 4, there is a chief engineer PWD NH workflow.
Yes, Mr. Who is for the who's for the PWD? Yes, who has constructed the road?
Lordship, I have no idea regarding this.
Yeah, for the PWD.
Lordship,
Then can we pass an order without the lawyers knowing who has constructed the road?
Because it is required, because.
What have I said? I have heard the learned process for the parties. Huh? The. What have I, then what have I said? The. I cannot hear you.
The facts of the case is that the land of the petitioners were acquired for widening the Hailakandi bypass under the National Highways Act 19.
For widening of the Hailakandi bypass. Huh? No, full stop. The petitioners not being satisfied with the amount of compensation assessed for payment to the landowners, file an application for determining their grievance before the arbitrator. Full stop. Consequently, an arbitrator was appointed by the central government, and in terms of section 35, no, 3G, in terms of section 3G of the National Highways Act 1956, the arbitrator published an award, issued an award dated 1/7/2017. Stating that in case of the Hailakandi bypass, the land valuation needed to be revised with 2011 as the base year. First off. But you see, Mr. Council, this number 2 talks about Lala bypass, not about you.
That is all right, but it was mentioned that Lordship, as has been done with other bypasses. As has
Full
been
stop.
done in case of other bypasses.
It also stated that in the case of Lala bypass, the year of land valuation seems to be fine. Full stop. However, it should be valued as per the type/class, such as homestead, cultivation, arable, etc., as it has been done in case of other bypasses. That is at page 62. Huh? Though the arbitrator has not stated that land valuation should be done as per the type/class, homestead, cultivation, arable, etc. No. What have I said?
Though the arbitrator has,
No, don't say though. Yes, though the arbitrator has stated,
has not stated.
Yes.
that-
No, though the arbitrator has stated that the land valuation should be done as per the type/class of land, such as homestead or cultivation, arable, etc. In case of Lala bypass, he has also stated that the same should be done as had been done in other bypasses, in the case of other bypasses. On perusing the impugned order, dated 1/7/2019, issued by the respondent number 6, it is seen that the assessment made for compensation of land had been done earlier, by classifying lands in two categories, that is homestead and roadside land, and arable land. You see, homestead and roadside land, you make that and like this, that and the small form, huh? However, the land, however, the respondent number 6 have made a generalized assessment rate for compensation of lands for the Hailakandi bypass. Purportedly on the lines of the arbitrator's award dated 1/7/2017, without making any classification as was required to be done. Full stop. Next para. For better understanding of the issue at hand, the directions passed, the directions number 1 and 2 regarding awards, capital A awards. In the arbitrator's award dated 1/7/2016, 17 is reproduced below. Page 62, 1 and 2. You take awards 1 and 2, this one. Okay. Next para. The assessment rate for compensation made for acquisition of lands by the respondent number 6 as had been done in earlier land acquisition cases, and which is reflected in the impugned order dated 1/7/2019, is as follows. Page 80, from here to here, A. Next para. The land valuation assessment made by the arbitrator, made by the respondent number 6 in pursuance to the arbitrator's award dated 1/7/2017, as reflected in the impugned order dated 1/7/2019, is reproduced below as chart B, which is as follows. This one, okay? Chart B. The first one you make it chart A, okay? Make it chart A. This one chart A. Next. A perusal of chart A, which had been made in respect of earlier land acquisition cases, clearly showed that compensation had been made by classifying lands in the Hailakandi area and other areas, Hailakandi area, into two categories. Pusta. One category being homestead and roadside land. Pusta. The other category being arable land. Pusta. Chart B, however, shows that there has been no classification of land between homestead and roadside land on the one hand and arable land on the other, as was required to be done in terms of the arbitrator's award dated 1/7/2017. In that view of the matter, next para, in view of the above reasons, it is clear that the impugned order dated 1/7/2019 passed by the respondent number 6 in making land valuation of the petitioner's lands for payment of compensation has not been made in terms of the arbitrator's award dated 1/7/2017 passed in pursuant to section 3G of the National Highways Act 1956. Also, the same is accordingly set aside as it has not been, the same is accordingly set aside. Full stop. The point number 6 is directed to make a fresh land valuation report with regard to the rate of compensation payable to the landowners in the Hailakandi bypass area, by classifying lands in two different categories, that is homestead land and arable land. Full stop. The point number 6 may also make a subsequent classification, may make an additional classification, if required, in terms of the arbitrator's award dated 1/7/2017.
Lordship, this order, only the replaces only, Lordship, this order, Lordship.
Full stop. Read petition, no, it will apply to everyone. Why not?
Why not before, Lordship?
Huh?
Why not before, Lordship? Because it should be applicable to the petitioners only, Lord.
Lordship queried one.
They will all come here.
Lordship, one more query was there,
Huh?
I'm helping you out. Is that petition? Lordship, constructing agency, is there clearly mentioned?
Just a minute, please come here. I cannot hear you.
Yeah. Because your Lordship inquired who has constructed. Now this is clearly mentioned in page 64, DCP engineer PW NS works Assam, because that arbitration award was forwarded.
That will by the respondent number?
The respondent number, may not say. But that is a chief engineer clearly mentioned.
Respondent number 4.
4.
Okay.
Clearly
We have
mentioned below.
seen it somewhere in
Because
the
copy
beginning.
is forwarded to him.
Constructed by respondent number 4, huh?
Good.
The entire exercise should be completed by the respondent number 6 within a period of
6 months.
none. Okay, we'll do for the making of the land valuation report by the deputy commissioner, by the respondent number 6, in terms of the arbitrator's award dated 1/7/2017 should be made within a period of 3 months from the date of receipt of a certified copy of this order. Full stop. The payment to be made to the petitioners should thereafter be done within a further period of 3 months. The writ petition is accordingly disposed of.
Obliged.
Thirteen,
Well, that refund of tax.
Lordship, our draft affidavit is ready. We'll file it by third.
oh, your draft affidavit is ready.
Lordship.
You'll be filing it when?
We'll be filing it by third, Lordship. This case can come up after Bihu vacations.
What is the matter about? What is the stand taken by you?
Not making Lordship, as far as the instructions are concerned, the writ petition is not maintainable and we have cut the amount as per the TDS.
Huh?
As per the instructions are concerned, Lordship is saying that the writ petition is not maintainable.
That's all.
Yes, Lordship.
That's the only case, that's the only ground.
And the TDS has been cut as per the provisions of law.
That's all.
We are not disputing that. The question is this. We have deducted the TDS and deposited after 2.5 years. As per the rules, my lord, it has to be within 10 days. That is number one. Number two.
So you are asking for interest.
No, I'm asking for refund of the excess pay, VAT paid, my lord. Because the authorities has deducted from turnover, my lord, the at source. Subsequently, TDS also being made from that bills, my lord. So that TDS amount is the excess amount, my lord.
Just tell me the case. Since then, I don't think the other lawyers are ready, so you
My
can
lord,
start.
my lord. Yes. If your lordship comes with the documents, my lord, if your lordship, I'll explain it, my lord. Lordship may come to page 48.
Let's go one by one, okay?
Yes, my lord. Page 48, my lord.
Page 48.
8, my lord. This is the application which I made for refund of my tax, my lord. To the Assistant Commissioner, claim of refund against TDS challenge deposited by government departments, double taxation. We would like to apprise on the following. While invoicing of vehicles oblique delivery, we pay the current taxes applicable. While receiving the payment from the departments, they release us the payments after deducting taxes, though we communicate to them that the taxes relevant to the sale has already been paid by us. Delay in submission of this challenge VAT refund claim has happened due to non-receipt of TDS certificates and respective challenge from respective government departments. We are facing our internal audit objections on the above. We are now submitting herewith all TDS certificates with respective challenge, along with other relevant documents, including revised annual returns pertaining to our refund claims for the period 2009-10 and 10-11 by proper process. Request you kindly to arrange for early settlement. Now, lordship may see.
Now, who are you, first of all? Who are
I'm the
you?
Tata Motors, my lord. We are the manufacturers of vehicles,
So you're selling the vehicles?
selling vehicles.
You're the authorized dealer or what?
Yeah, we are the company, man.
You're the company.
Company,
So,
Tata
so,
Motors. So lordship may see.
so what has happened? Why, so this TDS was cut from where?
Yes, TDS from the sale of the vehicle invoices. Now, the TDS which they have deducted, they have not deposited to the authority concerned as they are required. This has been deposited.
Who has not deposited to
GMDA,
whom?
my lord.
GMDA has
GM
not deposited to whom?
To the tax authority, my lord, because they deduct the TDS.
GMDA had bought the vehicles from you.
Yes,
Okay.
and they need to deposit the tax, the TDS, my lord, because they deducted from the income. So that amount they have not deposited into.
They deducted it from your income.
From my income. Now, my assessment was done on the source also. That is on the turnover of the vehicle, as well as the TDS. The TDS could not be bought in because they have not deposited the TDS for 2.5 years. Therefore, my lord, when it has came to our notice that the TDS also been deducted, it's 1 crore 82 lakhs, and also an assessment being made overall turnover of the vehicle. Therefore, my lord, we said that this TDS amount, which is in excess in deduction, should be refunded to us. That is the plain case, my lord.
Okay, so the TDS should be refunded to you.
Refunded to us, no? Because otherwise you have deducted at source also then from the entire turnover as well as from the invoices also.
What have they deducted from source?
From the turnover, my lord.
From
Because
the turnover, what have they deducted?
they have deducted, I have the for lordship 48
crores 69,40,341. That is our tax liability. So they have deducted this 48 crores from the overall turnover of the company, as well as the TDS, my lord, which they
Are
have
they
not-
supposed to deduct that?
yes, they can deduct. It's not a thing, but
And
then
can they deduct
from
TDS
the-
also?
from that source, my lord, the
Ca-
TDS
ca-
will go up.
Okay, from that source, TDS will.
TDS, like a redeposit tax, my lord. Once we are deposit 10% from our professional bill is deducted as TDS, my lord. Once this entire assessment is being made, then this amount is adjusted. So here what happened, this TDS amount could not be adjusted because they don't deposit it to the authority concerned for 2.5 years. When they deposited, then we
So,
said,
so the entire, the tax that they are deducted from source. That is TDS, that is against your income. Correct.
that is from the invoices, which we have raised the invoices on purchase of vehicle. They have deducted
TDS deducted from where?
invoices, my lord,
From
because the
invoices. And you made, they made another deduction from the total, you said from the.
total turnover, my lord. No, normal method is this, my lord. This
Yes.
TDS is to be
You'll have
adjusted.
to explain to me, because I'm still.
Yes, no, normal thing is this, my lord, this TDS needs to be adjusted against that, because that has to be got deducted, because we have taken from turnover entire this thing, as well as the TDS is another from invoices. So this TDS needs to be adjusted against the total turnover. As because they have not deposited in time after deduction of the TDS, assessment year is 2009-10. Now they deposited TDS, my lord, precisely on, my lord, they have deposited TDS, my lord, 14/8/2013. Twice they have deposited, once on 6/2/2012 and another on 14/8/2013. So I'm taking the outer limit, my lord, 14/8/2013. And I need to make the application for refund within 180 days, my lord, as per rule 29. And I made my refund application on 29/10/2013.
No, but why should the TDS come back to you?
No, my lord, I'm not asking for coming back, because you have twice you have deducted at one on the total turnover and again on invoices.
So once they have deducted from the total turnover, that includes the TDS.
Yes, correct, your lord. So TDS could not have been, because
So TDS could not have been deducted at all.
no, they are bound to their TDS.
Ah.
But question is that they ought to have deposited this
They,
TDS
within 10 days,
within 10 days to the
authorities,
sales tax authorities, my lord.
sales tax authority.
Yes, these are, my lord.
Sales tax or income tax?
These are, my lord, the assistant commissioner of taxes.
And then what happens
If they
thereafter?
don't, because they have not,
And if they deduct, and if they give it to the sales tax authority,
then my
what happens?
turnover, it will be deducted from my that turnover taxes, my lord, the total taxes they have raised from my bills. As because they did not deposit, otherwise if they would have deposited, this money would have been adjusted against the total turnover.
Okay, so you made a loss.
Yeah, definitely it's a double taxation, my lord. This is not permitted under Constitution 265, my lord. So that is the case, my lord. And they orally said, they have not given anything in writing. Orally, they have informed us that it is time.
So,
bound.
but usually, so they deduct TDS and they deduct from the total
Bills.
turnover,
Yes.
but they have to deposit that TDS within 10 days.
Within 10 days.
So they have to deduct both actually. The double taxation has to be there, but they have to submit it within 10 days.
My lord. Like it's a simple thing, my lord. Like we deposit when taxes, my lord. So our some bills are coming, professional bills, they deduct TDS 10%. If they don't deposit that amount in time, then I don't get the benefit in the total tax amount, my lord. It is something like that. And there was no assessment for a period of 5 years. Therefore, they are barred from assessing now. Because neither under section 35, 36, there was no assessment for 5 years. They need to have assessment. We are requesting them to assess, but they have not done it.
Yes.
We'll
You got now what the case is all about.
Yes.
Now-
Draft affidavit is ready, my lord.
Will it address the grievance raised by him? Is it going to redress
Yes. sir.
or answer the questions raised by him?
Yes, sir.
Yes, or hopefully.
They are on mental bit, but that I'll, my lord, place judgment on that.
Post it after 2 weeks.
Lordship may keep it as a part head and fix it on a particular date so that.
Keeping
This
partner
is
is like
2019
keeping
pending, my lord.
there are 2014 matters also.
But this is a matter of.
Keeping a case partner is putting a Damocles sword over your head. You know, anyway, now I've
But
got
let it be on, my lord, the third, my lord.
that photo, it's that
know,
with
my
that
lord.
celebration.
I know.
No
my lord.
time.
Then on 11th, my lord. On 11th, my lord.
After we go, lordship, let it be on 20.
Okay.
It is ready, my lord.
Every time we file our affidavit, lord.
All right, from Mr. J. Gogoi, learned counsel for the petitioner, submits that the respondents should be directed to allow the refund of rupees 1,82,62,867 paid in excess by the petitioner for the assessment year 2009, 2010, along with appropriate interest in terms of Rule 29 of the Assam VAT Rules, 2004. Full stop. The petitioner's counsel submits that for sale of vehicles to the GMDA, GMDA, comma, the GMDA had deducted TDS from the invoices and also made deduction from the total turnover.
No, not, they are not on that by the assessment authority, my lord. That's a different thing. It is, they're deducted on the invoices and the Commissioner of Taxes has deducted on the total turnover.
Okay, and the Commissioner of Taxes had made deductions from the total turnover.
Well,
Full stop. Without turnover, without making any adjustment with regard to the TDS
TDS, my lord.
that had been deducted by the GMD.
Respondent number 5.
Bracket is point number 5. Full stop. The petitioner's further case is that if the TDS deducted had been deposited within 10 days, as was required, then the deduction from the total turnover by the respondent number,
My lord, 3.
respondent number 3 would have been less the TDS deducted from the invoice. However, in view of the fault of the GMDA in making, in depositing
TDS.
that the TDS on 6/2/2012 and 14/8/2013, the petitioner had to pay more, had to pay extra taxes, Full stop. Next para, Mr. Yes,
Lordship, B Chaudhary's name may be recorded here.
Mr. B. Chowdhury, the learned counsel for the
Taxation Department.
for the taxation department, submits that affidavit is ready and the same will be filed within
By 10 days, Lordship, within 10 days.
10 days. This is the matter after the due vacation.
On 20, my lord.
Huh?
Date may be given, my lord, 20.
Okay, 20.
20 of DPW.
Obliged, Lord.
I'll come after this. I'll come after 5 minutes. After 2 minutes, I'll come. Item 3, is anyone ready? You are ready?
Yes, we are ready, but my learned friend has a prayer to make.
What?
Your lordship, the brief has been recently handed to Mr. M.K. Chaudhary. On the last occasion also, I saw some time.
You have been making this same excuse since some time back, I think.
No, this is the second time. This is not an excuse, Your lordship. In
Se-
fact,
second
my
time.
senior is in court number 1 today.
Okay, okay. So what do you
Your
want?
lordship can fix the matter day after tomorrow as per my senior's convenience. We have no objection to bring the matter, Your lordship. It is my seniors and legs for 2 matters in the hearing column in court number 1.
Thursday,
o'clock.
already something will have been fixed up. Already fixed. We'll listen after Bihu. What is it? What?
Only problem is the lordship only heard it. Just 2 things was about to be clear. That was the arguments were almost complete.
I know, but then every time we cannot keep adjourning cases to suit your timings.
If possible, also
Yeah.
Thursday you may try.
You see, we have fixed items. That's the thing.
As a lordship said.
Okay, list the matter on the prayer of the parties. List the matter on 11th. You'll try on 11th.
Yes, sir. Very well. As part of. 11.
Finish.
Oh.